Okay, good morning, everyone. As everyone does filter in, I just want to first say welcome you and thank you for attending today's Cover Your Assets Estate Planning webinar hosted by our Darrow Everett attorney, Benjamin Miller, a member of our private wealth services and tax practice groups. Ben will first present his PowerPoint slides and then take questions, and those can be asked by going to the chat box at the bottom of the screen or the Q&A that is right next to it. He'll answer as many as time permits. And then following today's session, we're going to send a link to the recorded presentation in the next 24 to 48 hours so that you can refer to it as needed. Ben will also be available for questions at bmiller@darroweverett.com should you need him, or you can also reach me as well. Ben, just want to say thank you for joining us. Really appreciate it. And the floor is yours.
Thank you, Roger. I really appreciate it. And thank you to everybody who's joining us this morning. We will be discussing everybody's favorite two topics, and that is death and taxes, right? I know everybody's super excited about that. And we're going to teach you how to cover your assets, okay? I took that title from my kids. My kids enjoy playing this game called Cover Your Assets. So I was initially going to put up the picture, but our trademark and copyright team advised against that. So instead, I'm just borrowing the term, and we're going to teach you. Hopefully by the end of this presentation, you will have a general idea of what is needed to cover your assets, your wealth, to protect what you have built up your whole lives, and kind of give you a general roadmap of where to go and what to do. So the first thing many people say is, oh, I already have an estate plan. Okay, so you may think you have an estate plan, but the question is your estate plan adequate, or do changes need to be made, right? So here are some reasons why somebody may need to update their estate plan, right? So what happens if you have an estate plan before you're married, right? And then you get married. So obviously, in that case, you're going to have to update your estate plan to include your spouse or future children. What happens if you get divorced and remarried, right? So you obviously will, or many times will want to take out the prior spouse and put in the new spouse, right? And if that new spouse has children, maybe include them, maybe don't, right? So what about if before you have children and you have an estate plan, and then after you have children, right? Or you adopt a child. So in these scenarios, you're going to want to update your estate plan to make sure that everybody, your loved ones, are taken care of, right? What happens if when you did your initial estate plan, your children were minors, and you appointed guardians, or you had certain distribution clauses that they don't get it to a certain age, and then now they're grown up and they're more mature, and so that's another reason to update your estate plan. Now this is very common, especially because I'm down here in Florida. I mean, we've had so many people move down here. What about people who had an estate plan when they were in New York, right? New York has different provisions and different requirements, different state laws, and now you're in Florida, right? So it's very possible that you're going to need to update your estate plan. And lastly, what happens if you sold a business, you have the proceeds now of the business, and you may want to do different things with that money, right? So all these reasons are reasons to update your estate plan. So even if you think you may have an estate plan, it may be old, it may be 10 years old, and many things have changed since then. So it's probably a good idea to update your estate plan if any one of these things happen. And this is not an exhaustive list. There's other things that may have changed in your life, right, that you may want to consider updating your estate plan. Okay, so there's almost always a reason to check in, do an estate plan audit, so to speak, to check on your estate plan to see if it's current. So why consider doing estate planning at all, right? Who cares? Okay, I'm gonna die. It's not my problem. Well, if you care about your loved ones and you don't want to leave a mess for them, there's many reasons to consider estate planning, right? Now, these are really ordered kind of in different tiers of estate planning. One and two would probably apply to almost everybody. Three, four, and five, I guess it would be, tier two, tier three, as somebody's estate increases in value, right? But there's almost always a reason to do estate planning. So we're going to start with, guardianship for minor and children and incapacitated persons, right? What to do if both parents pass away, who's going to take care of the children, who's going to take care of you if God forbid something should happen, you become incapacitated, right? Number two, intestacy. We're going to go through each state and how it works if you don't have any estate plan, right? What do the statutes look like? Number three is probate avoidance. Four is state tax avoidance, and five is asset protection. So these are really different tiers of estate planning, and we're going to go through each one at a time. So guardianship for minors and incapacitation. So what happens if both parents pass away, right? And there's no will, there's nobody appointing a guardianship for minor children. So what happens is the guardianship court will first look to estate documents, and if there's no estate planning documents, the court will then look to who's a responsible person to take care of the children, who is next of kin, who's related to the child. I put here Rhode Island statute. Every person authorized by law to make a will may appoint by will, subject to the approval of the probate court, a guardian or guardians for his or her minor children. So the Rhode Island statute authorizes everybody to appoint a guardian, but if there is no guardian appointed, the court will then evaluate who should take guardianship of the children. Now, I know myself, I have 4 boys. I would not want to leave it up to a court to make the decision who should be appointed guardian of my children. I mean, me personally, I have my in-laws live close by, but they're, getting up there in age, and I don't know if they'd be able to handle 4 boys, right? On the other hand, my parents live in Toronto, and they're far away. So, who would the court appoint? That would be up to them, right? Most likely they would appoint my in-laws, but, everybody, I assume, would want to take responsibility, would want to, at least show the court who should be the guardian of their children. And again, it's up to the court to decide. I mean, the court has the ultimate discretion, but if somebody is appointing a guardian for their children in their will, I should hope that you would appoint somebody responsible, somebody that the court would look favorably upon to accept that guardianship, to accept the appointment of the guardianship. So that is very important. I mean, for everybody with minor children has to have some sort of guardian appointed for the children in order to leave it up to the court, which could be a scary thing. Now, guardianship also applies to incapacitated adults and elderly people. Somebody who's getting up there in age would want to appoint somebody to be a guardian of them in case something happens. And again, you don't want to leave it up to a court. I personally dealt with a case here in Florida with an elderly woman who was terminally ill, but 100% lucid. This woman was sharp as a tack. And she approached me initially to draft her will. She wanted to leave all her money to charity. She felt her son didn't need the money. She didn't have a great relationship with her son, but she wanted to leave everything to charity. When her son got wind of that fact, that she wanted to write him out of the will, the son reported to the probate and guardianship court here in Miami-Dade that his mother was incapacitated. So at that point, what they did was they actually appointed the son, who obviously had a vested interest, as the guardian for his mother. Now, that even happened even though her husband was still alive. They appointed the son. And what ended up happening was the court placed an injunction on myself and the other attorneys drafting her documents that we couldn't do anything further. Now, none of this would have happened had the woman had in her documents an appointed guardian for in the event that she became incapacitated. Because she had nobody, right, appointed at that time, the court took it upon themselves. The son happened to be a doctor himself, so he was trustworthy, right? On paper, he was certainly trustworthy, and they appointed him. So again, none of this would have happened had she had prior documents, had she not waited until she was terminally ill to do this. So had she appointed her husband, her husband would have been the. I mean, that's usually the case where one spouse appoints the other spouse, but not always. The woman ended up passing away, and she didn't have any estate documents when she passed away. The estate was about $10 million. So it's not chump change, and that all went to the son because she had no estate documents and she had no guardians appointed prior. So it's very very important to have guardians appointed, to have these caretakers, so to speak, appointed in documents in order to avoid discretion by the courts, because it's a wild card, and you don't want to leave anything up to chance, especially when it's dealing with your children, when it's dealing with yourself, right? You don't want to leave it up to chance. You want the best providers to be appointed and to give you that peace of mind when you're no longer here. So moving on to intestacy avoidance. So if somebody dies without any estate documents, what happens is the state of a person's residency, the statutes of the state of a person's residency is a guide, will govern where those assets go. Okay, so I put here Rhode Island. This is the Rhode Island statute. If someone passes away without any estate documents, so it'll pass through. So if you die, what happens? So children, but no spouse, right? Children inherit everything. That's obvious. But now spouse and parents, but no descendants. So this is a little interesting. Real estate, spouse inherits up to $150,000 worth of your intestate real estate, plus the right to use the rest of it for life. And personal property, spouse inherits $50,000 worth of intestate personal property, plus half the balance. And then parents inherit everything else, which is interesting. That's just Rhode Island statute. So if that's not what you want to happen to your assets, then you need, at least at a bare minimum, you need a will to govern where your assets will go after you're no longer here. Now, Florida is a little different, right? Florida, it differs from Rhode Island because 100% of the estate goes to the surviving spouse. So if you see here, children but no spouse, again, children inherit everything. Spouse but no descendants, this is, right, it differs from Rhode Island. The spouse here inherits everything. Now, what happens, spouse and descendants from you and that spouse, and the spouse has no other descendants, then spouse inherits everything. So again, this is a little bit different than Rhode Island statute. Now, again, if this is not what you want to happen to your assets, then you must at least, at a bare minimum, have a will. The will, you can put basically whatever you want in there, however you want your assets to go once you're no longer here. That's what you can put. There are some exceptions. There's the elective share. You can't complete one. Somebody can't completely write out somebody's spouse. Every state has a different statute on that. But bottom line is, if you want to govern where your assets go, you need at a bare minimum a will. Otherwise, the state of your residency when you pass away will govern how your assets go. So how do you avoid intestacy? So again, you must have a will. Your standard will should name who is the testator. It's typically for a man, testatrix for a woman, the state of residency of that person. So again, if they are a resident of Rhode Island, the will should state that they are a resident of Rhode Island, right? If residency is Florida, the will should state it's governed by Florida law. it must state at the beginning of the will that this will revokes any prior wills, right? That way there's no conflicts between two wills, right? If you have two wills, the court might, and it doesn't have this clause, right? The court might look at these two wills in tandem. So you don't want that. You want to make sure that this will states that that it revokes all prior wills. Now, very important, in the will, it appoints, you must appoint a personal representative or executor. Some states call it, it's the same thing. That is the person who will take control over your estate once you are no longer here. They are basically the representative of your estate to carry out your wishes, right? That person could be a spouse, it could be a child. It just has to be somebody who is responsible, somebody who's going to be able to administer your estate the way you want it to go. So it's very important to appoint somebody who is responsible. Again, number 4, appointment of guardians for minor children, very important. And lastly, obviously, in order to avoid intestacy, you must appoint how your assets, tangible, intangible, digital assets, right? That's very important nowadays, especially more and more crypto or whatever people have that are digital assets. Those things must be appointed in the will in order to avoid intestacy. So not everybody listens to this advice. You look through history and famous celebrities have not heeded this advice and they have died intestate, which is a very large shame. I mean, look at Bob Marley in 1981, $30 million, right? Prince in 2016, $300 million. Picasso in 1970, $250 million. Probate estate costs $30 million to carry out. I mean, what a waste of money. It's ridiculous. It's total waste of money and unnecessary. Amy Winehouse, 4.6 million. Dr. Martin Luther King, I don't know his estate value when he passed away, but still, it's a waste. It's just unnecessary. And why leave it up to the state statute? Just it's very, very simple to take care of it. It's costs very little. I would say it costs about $500 or maybe $1,000 at most to draft a basic will to simply avoid intestate, appoint guardians. I mean, it's just very, very, very simple. Now, even if you avoid intestacy laws and you have a will, right, your state will still go through probate. Now, what is probate? Probate is essentially a court system that will approve everything in your will. Again, the court doesn't really have discretion per se, but they do monitor everything that goes through probate. So if you just have a will, what happens is when somebody passes away, the personal representative will either hire an attorney or do it themselves and send in the death certificate to the probate court along with your last will and testament. Then they will open up a probate court case. Opening a probate case from start to finish could easily last 6 months. Sometimes it could last a year or more. If basically what they do is the probate court will announce that such and such a person has passed away. And once they announce it, all creditors can then come and make claims on the estate. And if there's a contest between, let's say, siblings and they file something with the probate court, it can take even longer. It takes a long time. It's expensive. The attorney's fees are expensive. And most importantly, everything in the will is public record. We're going to see later on, we're going to see Michael Jackson's will was made public, and I'll show it to you shortly. But I mean, everything is public record. It takes a long time, and a judge has to approve every distribution from the estate. So it takes a very long time, and it's a huge hassle. So it's definitely one of the drawbacks to only having a will. So how does somebody avoid probate? Well, it's very, very simple. A trust, okay? There's 2 types of trust. There's revocable and irrevocable, but all you need to avoid probate is a revocable trust. Revocable trust is very simple, and it's just like it sounds. It's revocable. So who are the parties of a revocable trust? So you have the settlor or the grantor. That is the person, that's you. If you gift something to a trust, you are the settlor of that trust. The trustee for a revocable trust is usually the settlor or the grantor, and they are the person who have full control over the assets while the assets are in trust. Usually the settlor is the initial trustee, and then they have a successor trustee once they are no longer alive. Um, you know, it's really not enough to just have a revocable trust. You have to put assets, you have to assign or transfer assets into the revocable trust in order to avoid probate. So after somebody settles a trust, if they have bank accounts, you have to put those bank accounts, retitle those bank accounts in the name of the revocable trust. If you want to put real estate in there or LLC membership interest, you have to put those, assign them into the revocable trust. Now that's tax free. There's no, sometimes there are transfer taxes depending on the state for real estate, but generally speaking, there's no tax consequences to putting anything in a revocable trust. Now, once something is in a revocable trust, it avoids probate and avoids all those things we spoke about before, right? The taking possibly a year or made public. All those things are avoided if you put it into a revocable trust, and it's very, very simple to set up. And the annual administration is virtually nothing, right? It's really just, it's you control everything, and it makes everything nice and simple. It's a very, very easy solution. So I mean, just briefly to go over what is the difference between a revocable and an irrevocable trust. I mean, many people are scared. They hear the word trust and they think it's complicated and complex. So yes, it could be complex, but that's really a irrevocable trust. When you're dealing with a revocable trust, it is quite simple. So if you look on the left, right, so a revocable trust has flexibility. You can change the terms at any time. Irrevocable trust, you cannot necessarily change the terms at any time. It's a lot more, it's just like it sounds, it's irrevocable. With a revocable trust, you have full control, right? You retain full control over your assets. You're not giving up control. Irrevocable trust, yes, you are giving up a little bit of control. Estate tax, so a revocable trust does nothing for your estate tax, whereas an irrevocable trust could possibly help you avoid estate tax. And lastly, a revocable trust does not help you at all for creditor protection. It's not an asset protection tool, whereas an irrevocable trust could theoretically be used to avoid creditors and for use for asset protection. So when you're using a revocable trust to avoid probate, it is important to know that once you pass away, that trust does become irrevocable. So it's only revocable once you are alive. As soon as the settlor passes away, it becomes irrevocable. Now, again, I mentioned earlier that probably the biggest advantage, well, not the biggest, but definitely a huge advantage of using a revocable trust is that everything is kept private. You don't want anything public. Why would anybody want to air their dirty laundry or let everybody know how they are distributing their assets? So again, a huge advantage to revocable trust is the privacy aspect. Now, I mentioned earlier, right? Just drafting a trust does not do anything, right? You have to assign those assets into the trust. If you don't, right? If you don't assign the assets into the trust, then the trust is essentially doing nothing. I'll just show you. I told you I would show you this before. If I can pull it up here. So here is Michael Jackson's will. Michael Jackson had a revocable trust, and you could see that he had a revocable trust because his will is public record. If you see here, Michael Jackson Family Trust. This is a pour over will, what we call pour over will, because everything in his trust was supposed to pour over into his Michael Jackson Family Trust. Now, because he didn't actually assign anything to the trust, or he assigned minimal assets to the trust, everything was made public. Everybody could see here Michael Jackson's will. You can look it up yourself. It's completely public record how everything goes. I mean, who he appoints as executor. I mean, I don't understand why anybody would want their will public. So it's very important if you have a revocable trust, just having the trust alone does nothing. You must actually assign assets to the trust. Okay. And also, by the way, I skipped over here. This one, it's very important if you're going to have a revocable trust, you must name a successor trustee to take over once you are no longer around. Who is going to control the assets once the trust becomes irrevocable? This is an extremely important role. It's very important to consider somebody who is qualified, who's responsible and who wants to do it. I mean, you don't want to appoint somebody who's just going to resign as trustee right after they find out that they're a trustee. It's very important to notify the person who you are appointing as successor trustee that they are in fact the successor trustee, and just to let them know what the responsibilities entail, and to let them know, give them a general idea of what your assets are, what they're going to have to deal with. Now, many times you can, almost always in these trusts, there's provisions that state that the trustee can appoint or hire other outside professionals to handle certain aspects or management of assets of the trust. But it's important still to notify the trustee, to let them know what they are getting themselves into and make sure they are on board and qualified. It's very, very important. You can't just name yourself trustee and not name a successor trustee, because that's really when the trust will become irrevocable, and really more responsibilities will occur. So let's say somebody has an estate that is worth more than 13.61 million. Let's say a person avoided probate. Okay, great. But let's say now that a person's estate is significant, and they need to do some planning, because right now the unified credit amount is 13.61 million. In 2018, I believe it was increased from, I think, like it was like 5 million or 6 million, and it doubled to what is now 13.61 million per individual. In 2020, at the end of 2025, that 13.61 million it will go down to approximately 7 million. So anybody who passes away with more than that amount, anything over the 13.61 million or the 27.22 million currently, which will go down to about 14 million. Anybody who passes away with more than that will be taxed 40% on anything over that amount. So the estate tax avoidance is another element to estate planning. So it's very important if somebody has, now we're going to see in a minute what the 13.61 million, but essentially it covers everything. Everything you own will be included in the estate tax. Now, it's called unified because it applies, that 13.61 million applies both during life and at death. So what that means is you can either die with the unified credit amount, or you can gift it away during your life. Now, if you do make large gifts, anything I think more than 18 million currently, if you make, sorry, anything more than 18,000 annually to each recipient, if you gift that during the year, you have to file a 709 gift tax return with the IRS. Now, it doesn't mean you have to pay the tax, the gift tax. They just add it up. So every year, if you give, let's say $1 million every year, you file a 709 gift tax return, that's tallied. So once you hit more than the 13.61, then you will start to be taxed on those gifts. Now, why would somebody gift it now if it's just, let's say they gift a 13.1 million now, 13.6 million now, what happens if at the end of 2025 they reduce it down to 7 million? So anything that you gift now is not going to be clawed back, even if they reduce the gift tax to 7 million. So now that is why doing estate tax planning now is crucial, because if they do reduce it down to 7 million, you got it out, you got 13.61 million or 27 million out if you're married out now, before the exemption is reduced down to 7 million. So you could save millions if you take care of your estate tax planning now instead of waiting. Now, nobody really knows what's going to happen at the end of 2025. It could be that Congress will extend it. It could be not. Nobody knows. It's a wild card. But the point is, we know for certainty now that you have the 13.61 million. So there's about 18 months left before the end of 2025. Now is the time to seriously consider making gifts to irrevocable trusts. Now we're going to see in a minute that's the tool to use, but that is very crucial to consider making some gifts now in order to get rid of or reduce your taxable estate. So what kind of assets are included for estate tax purposes? Basically everything, right? Personal residence, vacation home, retirement accounts, brokerage accounts, business interests, life insurance. Very important to know about life insurance. If you own life insurance in your name, the death benefit will be included in your taxable estate. So even if you're thinking to yourself, hey, I don't have that much. I have my home, I have some retirement accounts, and I have my business, and then I have a $10 million life insurance policy. Well, I got news for you. Your $10 million of life insurance is included in your taxable estate, which will be taxed at 40% if your total combined estate is worth more than 13.61 million. I know a guy, he has a business that's worth probably $50 million, and some life insurance agent sold him another $30 million of life insurance in his personal name. So guess what? That person has just given away to the IRS 40% of the $30 million. So, I mean, unless you really want to give money to the IRS, I highly suggest you taking care of that and putting your life insurance in a trust, which we will see in a minute. So, how do you avoid estate tax? You avoid estate tax through the use of an irrevocable trust, right? Trusts do many things. Trusts avoid probate, they avoid estate tax, and we'll see at the end they add asset protection. So, in order to avoid the estate tax, you have to form a trust. Now, the best case scenario, for speaking about life insurance, is to form an irrevocable life insurance and have form an irrevocable life insurance trust and have the irrevocable life insurance trust purchase the life insurance from the get-go. So now, what happens? The irrevocable life insurance owns the life insurance policy, and then it's also the beneficiary of the life insurance policy. So when you die, you are the covered person, you are the insured, but the irrevocable life insurance trust is the owner of the policy, and it's the beneficiary. So when you pass away, you can see on the diagram here, when you pass away, the trust proceeds are used either to pay the IRS if you have an estate tax liability, or the trust can dictate that the assets go to your beneficiaries. But the point is that anything here in the irrevocable trust, life insurance trust, anything there is outside of your taxable estate, right? Usually what you need to do in order to do that, you need to appoint somebody else as a trustee, not yourself as a trustee. You have to give up some level of control over that life insurance policy. But usually somebody can appoint their spouse. They can appoint a trusted advisor. Sometimes people appoint a corporate trustee, depending on how you want to do it. But you have to give up a level of control, that is the mechanism, that is the requirement that will avoid the estate tax. But it's very, very important that you do this specifically for life insurance. But this irrevocable life insurance trust strategy works for all assets. It's not just life insurance. I just used this example here to illustrate how it works for life insurance trust. So now there's two types of irrevocable trust. Many people get confused. There is something called a grantor trust and a non-grantor trust. A grantor trust is a term for income tax, not estate tax. So you have an irrevocable trust to avoid estate tax. So that's one regime, right? The estate tax regime. But then there's the income tax regime. So you have an irrevocable trust that is a grantor trust. So what is a grantor trust? A grantor trust is a trust that has certain provisions in it that make the grantor, the settlor of that trust, the income taxable person. Usually one of the clauses which will trigger this grantor trust provision is that the grantor, the settlor, is able to swap assets or substituting assets from the trust with other property in a non-fiduciary capacity. So if you have that provision in there, that will make the trust a grantor trust. Now, there are reasons to do this, and we'll see, but it basically, you can transfer assets or sell assets to a grantor trust without triggering income tax consequences if it's a grantor trust, because it's essentially going from your right hand to your left hand, right? You are the taxable person of the trust, and you are the taxable person of your asset. So if you sell an asset into an irrevocable trust, grantor trust, you will not be taxed for income tax purposes. So if somebody sets up a grantor trust, they do not need to apply for an EIN for that grantor trust. Their social security number will be attached to any income that's earned with that trust. So it's a simpler mechanism for income tax purposes. A non-grantor trust is the exact opposite of a grantor trust. It does not have that provision in the trust, and it needs to apply for its own EIN. And trust accounting and trust taxes are a lot more complicated than for a grantor trust. So a non-grantor trust, its tax is calculated much differently than an individual, and it's a lot more complex. So the compliance will go up, meaning your accounting bills will go up if it's a non-grantor trust. So in order to avoid estate tax, somebody needs to settle a trust and not retain any incidents of ownership or control over those assets that are transferred into the trust. So, I mean, if you look at the second paragraph there, right, this is how the IRS defines incidents of ownership for life insurance policies. Right? An incident of ownership is a tax consideration for beneficiaries, right? So this includes, among other rights, the right of the insurer, the estate of the economic to the economic benefits of the insurance, the power to change the beneficiary, and the power to surrender or cancel the policy. So those actions will be considered an incident of ownership, and therefore it would be includable in somebody's taxable estate. So in order to avoid the estate tax by settling a trust, the settlor needs to give up all incidents of ownership. And by giving up your incidents of ownership, the trust is considered its own entity, its own person, so that it would not be considered you that's owning the asset when you pass away. It'll be considered the trust that owns that asset when you pass away. If on the other hand, you maintain some level of control over the assets, even after it's gifted to the trust, that asset will be considered in your taxable estate for estate tax purposes. So in order to avoid the estate tax, you have to give up all control, right? So, I mean, the best case scenario, which honestly doesn't happen that often, is if somebody settles an irrevocable trust when their assets are minimal. Let's say they just started a company, right? The company's not earning that much, but they anticipate the company, really taking off and doing very well. So it's advisable to gift that asset, that business, into an irrevocable trust while the value of that business is still relatively low, right? That way, once somebody gifts it or sells the asset to an irrevocable trust, once it's in the trust, any appreciation is completely out of their taxable estate. So let's say they gift the business when it's worth $1 million. Okay, so fine. So they've used up $1 million of their unified credit, right? So now they have, instead of 13.61 million, they have 12.61 million left of their unified credit, right? Now that business is in the irrevocable trust. Let's say 5 years from now, they sell that business for $50 million. That $49 million of appreciation that the business had after it was gifted to the trust is completely out of that person's taxable estate. So the $49 million, there's no estate tax on it. Yes, there will be income taxes on that. We're not talking about avoiding income tax. We're talking about avoiding estate tax. But that $49 million, if the person kept it in his estate, right, then he would have to now deal with that. And now he wouldn't be able to gift for full $50 million. He'd have to do what's called a part gift, part sale. We'll get to that in a minute. But the advantage of doing this is it's called an estate freeze. So you're freezing the value right, at today's fair market value of the gift. Once you froze the value, all appreciation is out of the estate. So this is a freezing strategy. The sooner somebody does this, if somebody has a business or assets that are appreciating quickly, the goal is to freeze that value of the asset while it's still relatively low. Now, the reason why I said at the beginning that this doesn't happen that often is because if somebody has a business, they don't know if it's gonna take off. They don't know if it's gonna do well, so they're scared to do this estate planning now when the value is low. They'd rather wait and deal with it when it's worth more. But it doesn't really make so much sense from an economic standpoint because the cost to do this is not that high relative to the savings that will occur if you do it sooner rather than later. Now, another benefit, by the way, to this whole thing is that you don't want to leave your assets necessarily to your children outright, right? If you pass away through an irrevocable trust, you can make sure that the asset, once you pass away, will stay in the trust, and not go outright to your children. This has many benefits for asset protection, benefits that their children won't get it outright, and also just just from a responsibility perspective. I mean, if somebody has a 20-year-old, you don't want them to inherit a windfall of $5 million or whatever it is at such a young age. You want the assets to stay in trust to make sure that you stretch out the asset for as long as you can, right? And it's not squandered. So what happens if you didn't take my advice, right? And now your estate is worth $50 million, right? So you only have 13.61 million to gifts, right? If you're married, okay, so then you have 27, right? So you have the 13.61 million. What do? So one of the strategies that you can do is create a family limited partnership. The family limited partnership, what it does is it creates a discounting value opportunity. Okay, so what you're doing is you're creating a family limited partnership, which is split between the limited partnership interest and the general partnership interest. The general partnership interest has full control, and the limited partnership interest is a completely passive investor. So what happens is when you create this family limited partnership, and then you put the asset in there. So let's say you have a $50 million asset. You create the family limited partnership, assign the interest of your $50 million asset into the limited partnership, right? Split between the limited partnership and the general partnership interest. You automatically get for the limited partnership interest, you automatically get a discount of between 15 and 30%, right? So at the low end, if you have a 15% discount on a $50 million asset, right? So your asset now with the 15% discount is worth 42.5 million, right? Versus 50 million. So you've saved right there, right? You've saved about $8 million in valuation so that now you can gift out more of that asset. Now it's very important that these valuations for family limited partnership interest are done by a CPA firm or a qualified valuation firm, because what happens is when you do gift the asset, and you do take a discount on the family limited partnership, what happens is you have to attach the valuation to the 709 gift tax return. You have to show the IRS that you based it on a real valuation. So here's a sample family limited partnership structure. You have the Doe limited partnership, right? 1% is owned by the general partner LLC, which ideally should be owned by both spouses for asset protection purposes. And then you have the other 99% interest split between Jane and John Doe. Okay, so the 99% interest, which is split between Jane Doe and John Doe, that will be anything in that will be discounted. So right here you have $50 million and $10 million portfolio. That could be a discount between 15% and 30%. So I mean, if you take the 59.4 million of the 99% interest LP, right, you'll get a discount between the valuation will be between 50.49 million at a 15% discount and 41 sorry, yeah, you'll get a discount between 50 million and 41 million at the high end. So 41.64, I think would be 30% discount. So I mean, it's not complicated to set up this family limited partnership and get the valuation done in order to reduce the valuation before you gift it. Now, once you've done the family limited partnership, the goal is to do a part gift, part sale of the asset to the irrevocable trust. So you have the John Asset Protection Trust and the Jane Asset Protection Trust. Usually what happens is these are called SLAT, Spousal Lifetime Access Trust. It's a specific type of grantor trust that spouses can set up for each other in order to make gifts and sales of the assets to the irrevocable trust. So here what you have is Jane settles a trust for the benefit of John, and John does the opposite. He settles a trust for the benefit of Jane, and they each then gift or do a part gift, part sale of their assets to their irrevocable trust in order to freeze the value of the assets. Now, because the value may be more than the 27 million for the married couple, what they do is they do a part sale, and then the excess of the 13.6 million they sell to the irrevocable trust in exchange for the note. That's the promissory note here, right? And then the trust pays off that note. It has to be done at AFR rates or applicable federal rates, which I think now is hovering around 5% for long-term rates. So what happens is the trust will pay off the excess of the 13.61 million over time. Now that's kind of beneficial anyways, because John takes the notes and he can use that money to live off of, right? And Jane can do the same thing. Now, it is important to know that when you do this part sale to the trust, the note that you take back from the trust is includable in your taxable estate. So how does one avoid paying estate tax on that overage? Because remember, you've used 13.61 million on gifting the assets gifting the assets to the trust. Now the overage, right, is and you've used up your unified credit, right? So now what? Let's say you've done that now, and let's say it goes down to 7 million next year. So you have this promissory note now stuck in your taxable estate. What do? How do you pay that? So very simple solution. We discussed the irrevocable life insurance trust before. You form the irrevocable life insurance trust, which buys life insurance in order to pay the estate tax that you may have to pay from that promissory note being includable in your estate. Now, lastly, one of the advantages of trusts and estate planning is asset protection. Asset protection is all about removal of control from the assets. So when you gift the asset to an irrevocable trust, ideally you have a corporate trustee who will be the trustee of the trust, and they will have full control over the assets. Generally, these trusts are structured as purely discretionary trusts with a spendthrift provision in there. Now, what that means is if you are sued, the trustee will not make any distributions to you as the beneficiary. So in other words, if your creditors come after you and say, hey, we know you have business, you say, no, the trust owns the business and I have no control. The trustee has full control. Now they can sue the trust, but generally speaking, in certain jurisdictions, it's very hard to get the asset out of the trust. If you gift, the goal is to gift it or transfer the assets to the irrevocable trust before you are sued, before your creditors are after you. Once your creditors are after you, it's a different story. But if you do it before, then you are generally covered from your creditors. Now, there are certain states are better than others. I have a chart here quickly. So here's a chart of the best states. Steve Oceans, I believe, puts this out. It's a ranking of best states for asset protection trusts. Nevada, you can see, is number one on the chart because it has a 2-year statute of limitations on assets transferred to the trust. So basically, if you transfer an asset and then after 2 years, your creditors come after you, essentially your assets are protected from your creditors. So the goal is for asset protection is transfer your assets before your creditors come after you, and have these spendthrift provisions in there so that if you are sued, your distributions will be cut off and your creditors will not be able to to get the assets. Now, anonymity is a huge part of trust planning, especially if you name the trust something generic, not tied to your family name. You name your trust the Blue Mountain Trust. Nobody knows who owns that asset, right? If they look it up, it's a lot harder to sue somebody if you don't know what they own. Nobody's going to sue somebody if they don't have any assets, so it's not worth their time. So if you cover your name and you cover your assets, right, essentially, it'll be a lot easier to avoid your creditors. And that is all I have for today. I hope everybody enjoyed it, and I hope everybody found it enlightening.
Very, very good, Ben. Thank you. And way to close with your title there. So nice job. Cover your assets. As
I
we
couldn't
await
help myself,
questions,
Roger. Yeah,
as we await questions in the Q&A box, as a reminder, that can be found at the bottom of your screen. I do have some questions for you, Ben. The first one being that I know you made it super clear that people should be doing all they can to avoid probate, but what other common mistakes should people be avoiding when they're doing their estate plan?
sure. I think one of the mistakes sometimes people do is they'll appoint somebody who won't be qualified to handle the personal representative position, right? So I mentioned in my presentation that you make sure you appoint somebody who's qualified. You don't want to appoint. Also, make sure you appoint somebody who is going to be alive when you pass away. You don't want to appoint somebody even if they're super qualified, if they're 80 years old, right, or 90 years old, whatever, because they may not be around. And if they're not around, then who's going to who's going to have control over your assets? So it's very important you name somebody who's both qualified and who is likely to be around, when the time comes.
Understood. And the first couple questions have already come through the Q&A feature. So Ben, if you want to go ahead and read from those, and then I think if you can just simply restate the question for those that are simply just listening, would probably be very valuable too.
Sure. So the first question I got here, uh, so so my mother-in-law lives in Florida. She has a trust, but I don't think her home is in the trust. We are concerned if she needs to go to a nursing home, the trust is unprotected. So we know it can be seized or paid for a nursing home, right? So this deals with a special needs trust or a Medicare trust or a Medicaid trust. Every state is different. Yes, you should probably consult with a special. These attorneys are generally elder law attorneys, and they deal specifically with Medicare and Medicaid trust. Every state is different. Many states have what's called there's a look back period. So some states are 5 years. So if they transfer the asset within 5 years of going to the nursing home, then they can take back that asset or be included in their estate for Medicaid planning. So that's its own specialty. But yes, you should definitely look into that, and go to a qualified professional. The second question is when you put money when you put the money in the estate and that avoids estate tax, do individuals in the trust take the money out? Are they taxed a regular income? So that will depend. If you put it in an irrevocable trust to avoid estate tax, in the determination of whether it's considered regular income will be considered if it comes. There's two buckets, right? There's two buckets of a trust. If it's a grantor trust, then no, there won't be income tax consequences. But because if it's a grantor trust, they will be taxed. The grantor, the settlor, will be taxed as soon as there's income in the trust. So if they take it back, it'll be considered a return of principal. If it's a non-grantor trust, it gets more complicated. There's two buckets of income within the irrevocable trust. There is DNI and UNI. DNI is distributable net income, and UNI is undistributed net income. So again, that's why I said before, non-grantor trusts are a lot more complicated when it comes to income tax. The accountant will really have to determine if that income is how that asset is taxed from an income tax standpoint. So the answer is it's complicated. and the accountant likely will need to opine on that. So it'll really depend.
Understood there, Ben. Okay. Next question I have here. Is there any income tax benefits to estate planning?
So income tax planning and estate tax planning actually they converge uniquely when you're dealing with qualified small business stock. I actually just wrote an article on this a couple days ago on JD Supra. You can check it out, but it's basically with qualified small business stock, which has its definition. Its definition is it has to be originally issued stock, less than $50 million of assets when the stock was issued, and it has to be active business, right? There are other requirements. Basically, if you gift, you can use what's called a stacking strategy, where if you stack the qualified small business stock by gifting your qualified small business stock to irrevocable trust for your children, you can increase your income tax benefits for qualified small business stock. So qualified small business stock is you can exempt either $10 million up to the greater of $10 million or 10 times your basis in the qualified small business stock. So let's say your stock is worth, let's say, $8 million. So if it's worth $8 million, you can gift your shares to 3 irrevocable trusts. Each irrevocable trust will be able to exempt its own $10 million, right? Up to $10 million. So you can triple, quadruple, depending on how many irrevocable trusts you create, you can increase your income tax benefits by stacking your qualified small business stock. So yes, Roger, there's definitely an advantage of trust planning for income tax purposes, specifically when it comes to qualified small business stock.
Understood. That's a link, everyone, that I can share with you when we do share the slides and the recording of this presentation, so that you're armed with that information as well, should you benefit from it. Next question here. Just I know estate planning is really dependent. Oh, let's go back. I want to make sure that this one gets answered. There's a follow-up to the prior answer that you gave there, Ben, in the Q&A.
Yeah, so the person wrote, yes, but when the person takes the money out of the estate, is it subject to income tax, not business individual? So yes, it will be. If the question is, will the settlor be subject to income tax? Again, that will be dependent on if it's a grantor or non-grantor trust. Let's say suppose the irrevocable trust earns income in year one, and that income is not distributed in that same year. Okay, and it's a non-grantor trust. The trust will have to pay the income tax. Then, if the individual then, after the trust pays the income, takes it out, it will not be subject to income tax because the trust has already paid the income tax. I hope that answers the question. But the bottom line is, again, a CPA will have to determine the exact calculation of how that's going to work. But yes, there is income tax consequences. It depends, again, if it's grantor or non-grantor trust and when the income is distributed from the trust.
Understood. Okay. I know estate planning is going to be very dependent in terms of how much time it takes for people, dependent on their circumstances, right? But can you share what might be a good baseline that people should understand that an estate plan would require for, to actually get set up and to have something that, like we said, is just a baseline for people that don't have one, that don't have one.
So it'll really depend on the nature of the estate plan, right? So a typical estate plan, or I should say a basic estate planning, right? So when I say basic estate planning, I mean a pour over will, a revocable trust, and the ancillary documents like a durable power of attorney, which is who's going to take care of your financial decisions, healthcare circuit. That plan will hover between, I would say, between $4,000 and $5,000 for the basic estate plan. The more the more complicated and the larger the estate when you're dealing with irrevocable trust, how many irrevocable trusts, it obviously the cost goes up, right? So it could cost about $15,000-$20,000, maybe more, depending again on how complex it gets, how large the estate is, and how many transactions will need to be done. But yes. Oh, I
Understood.
see another.
And
I see another question here.
yep.
So if you transfer stocks with long-term gains into the trust, how would it be taxed to the beneficiary of the trust, right? As regular income, so if you transfer assets, the for gifts, the stock retains its holding period. So the transferee or the trust in this case will jump into the shoes of the transferor. So if the transferor held the stock for 5 years, the trust now will take that. It's not going to start over. So it's going to be long-term capital gains is the answer.
Right. And final question, Ben. What other professionals might be involved in the estate planning process? I know it's just not attorneys at times.
Yeah. So I mean, estate planning it's a group effort. So it takes a CPA, right? It takes a village, right? So it's a CPA, life insurance guy. Many times you have the CFPs, right? The financial advisors. It's a group effort. It's a team effort. So it's not just the attorneys. In order to have a successful estate plan, you need everybody on board, everybody on the same page.
Hear you there. Okay. Ben, we are up on time. Really want to appreciate you for taking the time and also for everyone who was in attendance today. Thank you so much. Additionally, like we said, we will be sending the slides to Ben's presentation to you in the next 24 to 48 hours, as well as a link to this recorded presentation so that you can refer to it in the future. Ben is also available for questions. As we mentioned before, his email is very easy to remember, bmiller @darrelleverett.com. And certainly, me as the person who was inviting people, you are welcome to respond to me, and I will make sure that Ben gets, what you need from him.
Thank you, Roger.
Okay. Thanks, everyone. I appreciate you. Bye bye.